We have a court explainer from Court Helicopter News, and welcome to it. Today we are asking, why are there different decisions when it comes to bail? People have similar offenses. This court magistrate or this judge releases this person with a cash bail of 10,000 shillings. In a similar offense, another magistrate denies that person bail. In another court, similar charges, that person is given 1 million shilling as cash bail. Why is there no uniformity in terms of cash bail? Number two, why is the procedure of asking for bail and asking for bond in some courts different from some other courts? Is there a policy guideline that deals with this matter? Third, have you gone to court with your relative? Then your relative is told they cannot be given bail. What are the options when you have gone to court and you have been denied bail? These are some of the issues that were there for many, many years until the judiciary has now come out with a policy document. This policy document is called Bail and Bond Policy Guidelines. The Bail and Bond Policy Guidelines. It is now a document available on internet. It is available for everybody to bring uniformity. In the objectives of this is to bring certainty in the regime of bail. So what are the points? What are the considerations that a magistrate, that a judge will use to determine the bail or the bond terms of a person? In 4.9, of, that is bullet 4.9 of this document, the judiciary has provided a proper policy guideline, points to be considered when somebody makes an application for bail. Number one, the nature of the charge or offense and the seriousness of the punishment to be meted if the accused person is found guilty. The first thing when somebody is asking for bail, the court looks at the nature of the charge or the offense. Is it a very serious offense? The seriousness of an offense is determined by the punishment provided for. Under the law, there are petty offenses. They are called misdemeanors, where somebody is not going to be jailed for more than 6 months. Those offenses are easier. They can be, the bail terms are simple. There are serious offenses called felonies. A felony is a serious offense that one is going to be jailed for over 3 years. Such offenses are very serious because the punishments are heavy. Offenses of sexual in nature, defilement, incest, homosexuality, lesbianism, rape, they are very, very serious offenses because on the impact on the victim. Offenses of bodily harm, for example, grievous bodily harm, where somebody has used a panga to cut somebody, that's a very serious offense. Murder, where somebody has lost a life, that is a very serious offense. The punishments are for life sentence. Offenses like robbery with violence. Robbery with violence, the punishment is capital sentence. You're going to be killed or you're going to be left. The court will have to look how serious the offense is and what the punishment is provided for. That is point number one. Number two, the strength of the prosecution case. What is the evidence the prosecution have against this accused person? Some offenses, prosecution has no solid evidence. But sometimes you will see the prosecution, when they are opposing bail, they will bring an affidavit to oppose bail. They will show how their evidence is watertight. They will show that this person is likely to escape the country because we have very, very strong evidence against this person. So if the prosecution's evidence is tight and strong, it will make the judge or the magistrate deny bail or put serious terms for bail or release that person without any condition. Third, the character and antecedents of the accused person. The character, there is no one accused person who looks like the other. I'm not talking about the character and the antecedents in terms of the physical appearance. Don't take that line. It is the character of this person. For example, the prosecution tells the court that this person, he committed the offense in Mombasa. He ran away to Wajir. He has been hiding for the last 5 years since he murdered this girl. That character, once it is brought in court, the court will be very, very hard on that person. The character of this person. How many other offenses has this person committed? The DCI has a data bank of people's previous criminal records. They are brought in court. So a first offender will be treated lightly than what we call a recidivist, a person who is continuously in court. In terms of character, for example, in Milimani court, pleas are taken in 2 or 3 courts. Every day you are there. Today you are charged with this offense. Tomorrow you are brought with another offense. A traffic court, every other day you are being brought in the same court for overspeeding. Your character and your antecedents will determine whether you are going to go to court. Your image before the court. The courts look at you. The demeanor of the person in court. Do you look remorseful? Do you look somebody responsible? Do you look like somebody who is a criminal? Students of law, for example, Joy Gituma and Calvin, will tell you that there is a theory of Lombroso. The theory of Lombroso in criminology tells you the physical features of a criminal. The face, how the bone jaw looks like, how the elongation of the nose, how the eyes look. It is scientifically proved by Professor Lombroso that the physical features of a criminal are known. The judges and magistrates are trained. They see this. My good friend Vivian asks, How do the police always pick somebody from a crowd? They are walking from university, 10 girls, then the police pick at one. It is purely the physical features of a criminal, because the police are trained in the criminology aspect. Equally, the dressing. You have seen everybody who is being represented by senior lawyers, he'll be brought or she'll be brought in court, smartly dressed, looking presentable, looking somebody harmless. You come to court with your eyes bloodshot, with your hair unkempt, with your bling blings and bangles looking like a serious terrorist. The court takes notice of that. So character and antecedents will determine how one gets a lenient point while the other one is denied bail. 3, the failure of the accused person to observe bail or bond terms. Has this person ever been released on bail or bond? He failed to come to court. Some people are released at the police station by the OCS. Then they are told, go, come next week. They don't go to the court or they don't go to the police. So if the accused person has ever violated the bail and bond terms previously, that person will not be given bond. That person, if given bond, the bond terms will be very, very exorbitant, or even the existing bond terms can be cancelled. For example, you are released on cash bail. You are told, go home. The case is coming on 15th of March. You don't appear on 15th of March. The mention is given on another 2 weeks. You don't appear. The prosecutor will ask for your bond and bail to be cancelled. And once it is cancelled, a warrant of arrest will be issued. So how you have dealt with that question, number 4, will determine your bail and bond terms. 5, likelihood of interfering with witnesses. The accused person, is he likely to interfere with witnesses? Here the courts are looking at, who is this person? Is he a governor? And are the witnesses who are going to testify against him his employees? Then there's a likelihood that the governor, if he's released, he'll come back to the county, ensure the witnesses who are county employees are not involved. 3, if the likelihood of interfering with witness, is this person the OCS? If this person is the OCS, the witnesses are police constables. Is he likely going to interfere with the witnesses? Yes. So the court looks at that. The position the accused person is holding vis-a-vis the relationship of the witnesses that are going to testify against him. If there is an authority and power relationship, a junior with a senior relationship, if this is, for example, a child who has been defiled by a father, the child is still staying in the father's house, will this father be released to that house where the child is? No way. The court will reject that because he will likely interfere with the witnesses, that witness being a vulnerable child of that place. So that condition of likely interference is a very critical condition, especially with the people who have authority over their witnesses, with the people who have power over the possibility of the witnesses. 6, the need to protect the victims or victims of the crime. The court must look at who is the victim. I have just given an example. The victim is a child, a daughter, who has been defiled by a father. The court must protect that victim. The victim is an employee of Danstan Omari and Associates, a cleaner, a worker, an advocate who has been beaten by Omari, the boss. If Omari is released, will that employee survive? So those are the conditions the court looks at. The victim must be protected. The victim is a very fundamental thing. Under the law nowadays, the victims come to court. They hire advocates called advocates watching brief. They bring the sentiments of the victims. 2, the victims have a right nowadays to file affidavits to oppose bail. The victims are also called complainants. They are allowed to give their sentiments. You have been charged with the offense of murder. You come from the same region as the person you murdered. If you are released, the person you murdered has not even been buried. How do you expect the family to see? So sometimes the court looks at the victims and the voice of the victims. Also, victims are nowadays being represented by civil society. We have seen the Law Society of Kenya coming in to defend the victims. We have seen Kituo cha Sheria coming in to defend the victims. We have seen Sheria Mtaani come na Shadrack Wamboi coming to represent the victims. The voice of the victim is very, very important. It can make you be denied bail, or it can make your terms of bail terms and bond terms to be different. G, the relationship between the accused person and the potential witnesses. What is the relationship between the accused person and the potential witnesses? If there is any relationship that can bring you being denied bail, if the relationship is familial by blood, or is it by employment, that relationship? Is it by business? So that relationship, that connection has a say, and you can be denied bail or you can be given bail because of the relationship that you have. But the relationship, as I've said, is very, very critical in family relationship. Here is a husband and a wife. The wife has been battered badly by the husband. How will the court balance that? And the man has sworn, if I come, nimekamatwa, nikirudi, utakata we shingo. This is a wife, jobless. Will the court release this man to go and kill the wife? The court will protect that wife. So, this is what causes disparities in this place. H, child offenders. The accused person is a child. This child must go to school. Remember, we did the law on the Children Act and said there is no child, there is no criminal called a child. They are children in conflict with the law. So, these children found themselves in a mistake. The court must allow these children to go to school. So they will always get, where are the parents? Come here. We give you this child, may ensure you discipline this child and bring the child to court when the child is required. The court will look at a child offender differently from a hardcore criminal who has been charged with the offense of murder. Is the accused person a flight risk? A flight risk is not somebody taking a flight or an aeroplane. A flight risk is somebody who is likely to escape from the jurisdiction of the court. The jurisdiction of the court is within Kenya. So, is this person likely to escape? Here, we have categories of people who are automatic flight risk. One, a foreigner in this country is a flight risk. If you arrest a foreigner who has killed somebody, you release him to bail, he'll escape. So a foreigner is number one. Number two, a foreigner without valid documents to allow that person to be in this country. Somebody sneaked from Cameroon. He came to do gold scamming here. He's arrested. He has no document. You can't even say whether he's a Cameroonian, whether he's a Tanzanian. There is no document of identity. That person is called a flight risk. Fourth, the person committed a crime. He escaped and he was arrested at Mombasa, at Namanga port. At Namanga port, he was arrested trying to escape to Uganda at Busia port. Was picked out of the bus. He was found at Wajir, at Mandera, almost escaping to the outside the country. That person is called a flight risk. The person was arrested at the airport. He had already boarded a flight. That person is called a flight risk. Anybody who is likely to escape will be denied bond. Equally, for Kenyans, if you have no fixed abode, you have no home, you want the court to release you to where? You have no home. You have no residence. A home does not mean your permanent house. You have nowhere you have rented. So nobody can get your address. Originally, they used to be called vagabonds. Today, they are called people with no fixed abode. Three, you have no family linkage. Who are you? You don't have a father. You don't have a mother. You don't have a brother. You don't have a sister. You don't have an uncle. You don't have anybody. No familial. That is why you see lawyers will always tell your family to come to court. So that the court sees that this person is having a family. And if the family is here, then this person is rooted here. Lastly, the person has no property in Kenya. He's a foreigner, he doesn't have property. Why will he come back to this country? Failure to own property, if you are a foreigner in this country, you will not get bail, and your bail might be cancelled. Then we have J, whether an accused person is gainfully employed. Are you employed when you have been brought to court? Do you have a pay slip? Where do you work? May I work with Court Helicopter News? Where is your document showing you work for Court Helicopter News? That shows that you are able and you have an income. You cannot escape out of the country. So if you are not employed, the court looks at you differently because you are nowhere. What are you doing? Are you a student? bring the identity card of the multimedia university that I'm a student of journalism. I'm a student of law at the Kenya School of Law. And especially for those students who are joining the Kenya School of Law, we wish to give them a thumbs up. The first thing that you take, make sure you have an ID from the School of Law to identify you that you are a student of the Kenya School of Law, so that whenever you are found, I know you are going to be taught not to break the law or not to find yourself in the opposite side of the law. The identity of that person is very, very critical. Then we have K, whether the public order and peace or security is likely to be interfered with. The public order, the country, the President of the Republic of Kenya, the Inspector General of Police, and all relevant security agents have a duty to ensure the country is safe. Is the offense that you have been charged with likely to bring a breach of peace? You put, for example, the Gen Zs, you put the head of state in a caricature, in a coffin, that the head of state has died. Can that cause problem? If people believe that the President of the Republic of Kenya has died, can we get a security problem? You put a story that Somali soldiers, you have seen Somali soldiers with 1,000 tanks, they are already at Thika, coming to capture Nairobi. Can that cause public issue? You are charged that you were found with 1 million bullets and 1 million guns. Can that cause a breach of peace in the country? You are found with army equipments. Can that cause a breach of peace? You are found in a mall where the public going to that mall are 10,000 people at one time. You are found with poison on top of the water tank. You want to poison the water so that all these people in the supermarket die. Those are the issues that you are likely not to be given bail. So, the type of the offense, if it can cause a breach, you are not likely to go. You are being charged that you are a serial killer of women. You rape, you kidnap women, you rape them, you kill them. You have destroyed, you have killed around 20 women. Will you be released on bail? You will not be released on bail. So those issues where the charge, your charge can affect the public order. You have stood on a platform and said, all Kikuyus must be killed. All Luos must be killed. All young men or Gen Zs must be killed. That you cannot. That is breaking the bridge of peace. You will not be given an order. You have walked into a bar at night. You have thrown a tear gas canister into where people are entertaining themselves. That one, you will not be given bail. The law will deny you bail if there is evidence that your life is in danger as an accused person. Why do I say this? You are a university student. You attempt to burn a hostel and kill university students. The university students are looking for you to kill you. You will not be released to go back. For your safety, you'll be detained. You have killed somebody and your home is there. The public looks for you, they don't get you, they get your mother's cows, they kill them. They get your houses, they burn them. Can you be released to go back? You will not be released to go back. If it is the state's interest is to preserve life. Court helicopter now explains to you, these are the circumstances the courts look, and that is why we have different varieties of rulings, because the charge sheet is one. The offense one person is charged is rape contrary to section 4 or murder contrary to section this. The particulars is where the problem is. This is how was the offense committed. Somebody has been charged with murder. One shoots, one bullet, he dies. Another guy hits a punch, one, he dies. Another one gets a knife, he starts from the head, shaving the woman, cutting the nose, removing the teeth, removing the breasts, removing the arm, removing the toes, torture. The manner in how that person killed the other will determine whether he'll be released on bail or he will not be released on bail. So the same offense, all of them are murder. One will be released with murder with 10,000 shillings. Another one will be released with murder with 10 million shillings. Another one will be denied because of the manner in which he committed the offense. Today now, you know, don't blame the courts. The courts follow these guidelines. Each case is different from another. The offense is one, but the particulars, how the offense was committed, and after the offense was committed, how the accused person behaved will determine the terms and conditions of bail. Bail can be denied at the lower court. You have a right to go to revision at the high court for a review of those determinations, or you can challenge an appeal to the high court. You still can be denied bail at the high court, you move to the court of appeal and the Supreme Court. Bail at the magistrate's court, we don't file formal applications for bail at the lower court. At the high court, we must file by an application, we serve, and responses are done. It is a formal way of doing an application for bail in the high court. It's different from the lower court. Lastly, the court can issue the following as bond and bail terms. One, cash bail. That's money. You deposit money in court. Two, bond. Bond is a property, either a logbook of a car, a title deed of a property, or a pay slip. Those ones are called bond terms, or a share certificate of your shares in the banks and cooperatives. Third, the court can demand for somebody called a contact person. As you are being released, you get the contact person to come to court so that in the event they want to look for you, you look at it. These bond terms, there is somebody called a surety. A surety is the owner of the logbook, the owner of the car. The surety is the owner of what you call the title deed. They must produce documents of ownership. The title deeds must be brought to court. The logbook must be brought to court. The vehicle that is being insured, that is being brought, will be brought to court for inspection. Evaluation report must be done so that these people come to court and they prove that they are ready to forfeit their property if the accused person disappears. There are person we call the contact person. The contact person are those ones who come and give their details, so that whenever there is the person is required in court, if he can't be found, the court will call that person. Issue: can the court impose conditions? Yes, the court can impose conditions so that the bail terms, you are released with conditions, bond with conditions. What are some of the conditions the court can impose? One, if you are a foreigner, the court can impose that you deposit your passport and travel documents in court. If you are a Kenyan who travels out of the country, the court can impose an order for you to put your travel documents in court. Two, if you committed a crime in a certain place, the court can order that you don't appear there. You remember what happened when Sharon Otieno was murdered? The alleged murderer was the governor, Obado, of Migori. The court imposed conditions that the governor cannot go to Migori. He can work from outside. Equally, for example, in the ethics and anti-corruption cases, courts impose that governors cannot go back to their offices at the county headquarters until they operate elsewhere. So the court can impose conditions. Governor Obado was barred from going to Migori. Governor Natembeya was barred from going to his offices for some time for investigations to continue. The court can also order that you don't interfere with the witnesses, or you don't make any contact. You don't call the witnesses. You don't interfere with the witnesses. So the court can impose conditions to allow somebody to get bail to go. Lastly, what are the mechanisms the court has? Which instruments does the court apply to get to that decision? Under the law, the court has officers under it who will go to the field to get this information. There is a department called the probation in the ministry, the Department of Probation. There is also the Director of Children's Services. These are officers of the court. So the court can order, one, before we release you, there be done a comprehensive pre-bail report. A pre-bail report is a report where the probation officer will first of all interview you, the accused person. It will interview the complainant. It will interview the victim to know their feelings, whether they are comfortable for the accused person to be released. It will go and interview the local administrative structure. They will go and talk to your chief. They will go and talk to the DC. They will go to know this information. They will equally, if it is a sensitive matter, go to your pastor. Check, ask the pastor, ask the bishop, who is this person? They'll go to the community and get the information, how the community is feeling about this person. They will equally go to your employer, if you are employed, to get these details. Remember, you claimed that you work for Danstan Omari and Associates. They will come here to check whether indeed you work for Danstan Omari and Associates, or you work for Court Helicopter News. After this report is compiled, the probation officer will recommend whether you are suitable to be released on bail. The children officer will recommend to the court whether the child is suitable or the accused person is suitable to be released, and if it is in the best interest of the child. The court will now look at the report. The court, depending on the report, the bail report, 10 people charged with the same offense, one will be released on a cash bail of 5,000 shillings. Another one will be told, you will be released with a cash bail of 10 million shillings. You will not be released because the prebail report is not favorable. You will be released, but you will have to depose condition. So this is a tool that helps the court to look at how justice can be done. Then the court will pronounce itself. After the court has pronounced itself on bond and bail terms, you have a right also to make an application for review of those terms before the same magistrate. Not once, not twice, you are allowed to make an application for review severally. What will be the reasons to apply for review? One, you are told to pay a cash bail of 10 million shillings. After 14 days, there's a mention, you come back, you tell the court, my client or myself, I'm unable to raise the 10 million. You argue, the court can review and reduce the bail. The principal reason for bail and bond is to ensure attendance of an accused person in court. It is not a conviction. It is not a sentence. Bail is provided for under Article 49(1), Article 49(1)(h). But it is not absolute. Bail is not absolute. Bond is not absolute. If there are compelling reasons, the court will deny you bail. The compelling reasons are provided by the prosecution. So those ones who are inside and they have been denied bail, it is because there are compelling reasons to deny them bail. Those who are outside, there were no compelling reasons to deny them bail. But as we have looked at this policy guideline, the objective is to decongest prison, the remand prisons where the remandees are detained. And because of these policy guidelines, judicial officers, magistrates, and judges normally visit prisons. And when they visit prisons, they review the bail terms for those remandees who have failed to get bond and bail time. So the judges and the magistrates go and can release people who have failed to raise their bond terms and bail terms. Bail and bond is a continuous process. It can be reviewed up to the day of judgment, so long as judgment has not been entered. Lastly, when judgment has been entered and an accused person has been convicted, the bail and bond is cancelled automatically. It will become cancelled automatically because you are now a convict. The convict waiting for sentence. After you have been jailed, after you have been sentenced, you want to appeal. There is a new concept called, in the High Court, you want to be released on bail as your case is proceeding. It is called bail pending appeal. Your advocate or yourself, you will file an application to the High Court saying, I have been convicted for 10 years. I have an arguable case. Allow me to go out on bail and bond as the case is progressing. The conditions in this are different. Once you are convicted, it is no longer the principle that you are presumed innocent till guilty. You're already guilty. The only condition the High Court will release you is to show in your appeal that you are likely to succeed in your appeal. So you must show in your appeal that you are likely to succeed. That is the only condition that will allow you to be given bail pending appeal. Arguments about health, that I'm dying, I'm diabetes, my children are not going to school. Those are not arguments for one who has been convicted to be released on bail. You have seen it in Waititu matter. Those grounds don't matter. If you are unwell, the prison facilities have hospitals, they have doctors in the prison. If your condition goes beyond, they will take you to a government public hospital. Once you are convicted, my friend, my sister, my brother, you'll only see Nairobi Hospital, Aga Khan Hospital, Kwakot helicopter. You will not be taken there. You will be taken to a public hospital. We have now explained and sorted that big question. People are bashing magistrates because of different decisions of bail and bond. Wakili Danstan Omari, see you and have a nice, happy New Year.